This is passage number 8. Duration 6 minutes, speed 100 words per minute. Dictation starts now. The petitioner has filed this writ of habeas corpus challenging the detention order passed by the Commissioner of Police under the provisions of the Maharashtra Prevention of Dangerous Activities Act. The detaining authority passed the impugn order on the ground that the activities of the detainee are prejudicial to the maintenance of public order. The grounds of detention mention three recent criminal cases registered against the detainee involving offences of extortion and criminal intimidation. It is the case of the state that the detainee is a known slum lord and his presence at large is a constant threat to the safety and security of the local residents who are too scared to come forward and lodge a formal complaint against him. The para. The learned counsel appearing for the petitioner submitted that there has been an inordinate and unexplained delay in passing the detention order. He argued that the last criminal activity alleged against the detainee took place 6 months prior to the date of the order, and thus the live link between the prejudicial activity and the purpose of detention has been snapped. It is further contended that the document relied upon by the detaining authority were in Marathi, whereas the grounds of detention were served in English, which the detainee cannot read or write. This, according to the petitioner, has deprived him of his fundamental right to make an effective representation under Article 22 of the Constitution. Para. On the other hand, the learned additional public prosecutor defended the action of the state. He submitted that the delay was due to the ongoing investigation and the time taken to collect secret information from the witnesses. He argued that the procedural safeguards have been strictly followed and the translation of the documents was provided to the detainee's wife upon her request. The state maintains that the subjective satisfaction of the detaining authority is based on credible material and the court should not interfere with the merits of the decision. It was emphasized that the safety of the public at large outweighs the personal liberty of a habitual offender who has a long criminal history. Para. We have carefully examined the original files of the detention department and considered the rival submissions. It is a well settled principle that preventive detention is a drastic measure as it allows the state to detain a person without a regular trial. Therefore, the law requires strict compliance with the procedural requirements. Any lapse on the part of the authorities in providing the grounds of detention in a language understood by the detainee is fatal to the case. We find that in the present matter there is no evidence to show that the detainee was made aware of his right to represent his case before the advisory board in a language he understands. Para. Furthermore, the delay of 6 months in passing the order has not been satisfactorily explained by the department. In matters of personal liberty, every day's delay is important. If the authority takes an unreasonable amount of time to act, the very necessity of preventing the person from committing further crimes becomes doubtful. The subjective satisfaction must be based on a proximate and immediate requirement. In our opinion, the detention order suffers from the vice of non application of mind and fails to meet the high standards of legal scrutiny required in cases of habeas corpus. The right to life and liberty is the most cherished right under our constitution and cannot be taken away in casual manner. In view of the above discussion, the detention order is hereby quashed and set aside. The detainee shall be released forthwith unless he is required in any other case. The petition is allowed. No order as to courts. The state is directed to ensure compliance of this order without any unnecessary delay. Over. Stop.